Yo, it's JP. I'm going to talk today about EEOC mediation and why I typically think it is a bad idea for folks to participate in the EEOC mediation process. Number one, okay, we get lots of calls and emails from folks about EEOC mediation. Some of these people have been offered EEOC mediation. Some of these people have accepted EEOC mediation because they don't know what their rights are. They feel like they were obligated to do that. They don't understand the law. They don't have a lawyer. They're unrepresented. Worst case scenario, folks contact us and tell us that they participated in EEOC mediation. They didn't know what to do. They were under a bunch of pressure and they agreed to settle their case. And now they are having second thoughts and they want to know if they can get out of that settlement agreement. And the answer there is almost certainly no, you cannot. And that is why I say don't go to EEOC mediation. Okay. Who should go to EEOC mediation? Let's start there. Okay. Who should go to EEOC mediation? If you have a weak case, or if you're only trying to get, $5,000, maybe $10,000, then sure, go to EEOC mediation. That's fine, because if that's what your goal is, there is a reasonable chance of accomplishing that goal via EEOC mediation. But for everybody else, okay, if you don't have a weak case, if you have a real case, and if your goal is not to settle your case for, $5,000 or $10,000, stay out of EEOC mediation, okay? And here are the big reasons why. There are a lot of folks who get pressured in that direction, okay? They don't have a lawyer. They're unrepresented. They get pressured in that direction. They don't understand what their rights are, what their obligations are. Well, I'm here to tell you, you are under no obligation to participate in EEOC mediation if you don't want to. The EEOC can't force you to participate in mediation. Now, I know there are good EEOC investigators, there are bad EEOC investigators. There are certain EEOC investigators who act like and conduct themselves like they have a lot more power and authority than they really do. We've talked to a number of folks who have dealt with an EEOC investigator who was trying to pressure them to settle or trying to strong arm them into going to mediation. That's entirely inappropriate, okay? The EEOC investigator has no power. They have no authority over you. They can't force you to go to mediation. And quite frankly, unless your case is a weak case or a low dollar case, you have no business participating in EEOC mediation. You have every right to say no, and you absolutely should put your foot down and you should say no. Don't get railroaded into an EEOC mediation when you don't have a lawyer, okay? And then you're gonna be in that mediation, and now the other side's there, the company's there, they've got their lawyer and they got the mediator, and everybody's trying to press on you to settle your case. I've seen that happen. I've seen that happen 50 times if I've seen it happen once, where people went to EEOC mediation and they basically got strong-armed into settling. Don't do that. Don't put yourself in that situation. Just say no. Don't go to EEOC mediation. If you step back, okay, and at a higher level, right, looking at the whole landscape, I'll tell you why EEOC mediation is the wrong place for real cases and for cases where the damages are significant or you're looking for a significant dollar amount, okay? It's all about psychological orientation, okay? It's all about the company and the defendants being oriented in the right ballpark and in the right arena, okay? Let's think about it like this. If you go to the Dollar Tree, you are basically expecting to spend $1, right? If you go to the Dollar Tree, you're expecting to spend, give or take $1, a couple bucks. You're going to the Dollar Tree for a reason. Well, EEOC mediation is basically the Dollar Tree. That is corporate America and their defense lawyer and the insurance company going to shop at the Dollar Tree. And so they are expecting to be in that Dollar Tree and pay Dollar Tree prices. That is what EEOC mediation is. Their entire psychological orientation, okay, is right there at the Dollar Tree. That's what they're expecting to pay, Dollar Tree prices. You got to get them, okay? You got to get them out of the Dollar Tree if you expect them even to pay Target prices, okay? You can't have them be shopping at the Dollar Tree under the impression, right, we're here in the Dollar Tree, we expect to pay Dollar Tree prices. You can't have them there, okay? You got to reorient them like, no, this is Target, okay? This is Target, all right? And if you want them to be paying, right, for a Lexus, then you got to get them all the way over to the Lexus store. And you know where the Lexus store is not? At the Dollar Tree. You know where the Target is not? At the Dollar Tree. You got to get them out of the Dollar Tree. And EEOC mediation is the Dollar Tree. And they're expecting to pay a couple dollars and nothing more. Okay? It's about psychological orientation. So if you have a real case, if you have a case where there are either egregious facts, there was egregious discrimination, there was terrible retaliation, and whether there could be significant economic damages, or there might be minimal economic damages, but significant emotional distress, loss of dignity, humiliation, embarrassment, depression, etc. And those are real damages too, right? This is one of my biggest ongoing fights with corporate America. Corporate America and their defense lawyers look at so many of these types of cases, and I'll give you an example, right? They say, okay, well, the plaintiff in this case was called the N-word 78 times and 60 other racial slurs, and then he was fired for reporting it to HR. And yes, that's terrible, but he subsequently got another job after only a couple months out of work, and so, he doesn't have any real damages. Well, I say he has real damages. Just because he doesn't have lost wages, okay? Just because he doesn't have, more than $10,000 of lost wages doesn't mean that what he went through and endured should not be compensated. And in fact, not just compensated with compensatory damages, but the company's conduct should be punished with punitive damages. And fortunately, on a race discrimination case like that, you can get punitive damages, real punitive damages, not capped punitive damages, but real punitive damages under 42 USC 1981. But the defendants look at a case like that and they say, the guy's, he doesn't even have more than $8,000 of real damages. And that's nonsense, because real damages are whatever damages you are permitted to recover under the law. And the law clearly provides for both compensatory and, in many instances, punitive damages in these types of cases. But if you have a case like that, where you either have significant economic damages or the facts are egregious and you are, presumptively entitled to significant compensatory damages or even punitive damages, you are never going to resolve a real case like that via the EEOC mediation process. That whole process is not built for resolving real cases. That whole process is built for nickel and dime, okay? Now, I'll go a step further, okay? There are many cases that are real cases that get funneled into that process and settled for peanuts. They get settled for $5,000 or $10,000. They get settled for a fraction of what they're really worth. And that's all part of this overall market failure, okay? Think about it like this. There's a market for these types of cases. These types of cases are basically assets, right? You could put a price or put a value on them, okay? One, there's a shortage of plaintiff side employment lawyers. There's a shortage of lawyers who are willing to work on these cases, and there's a huge shortage of lawyers who are willing to litigate these cases, take these cases to court, let alone take the case to trial if it's necessary to go that far in order to get fair or reasonable value for the case. And so As a result of this shortage, many folks can't find a lawyer at all. And so you have folks representing themselves, no lawyer, okay, going through the EEOC process, go to an EEOC mediation, and they get their case settled for $5,000 or $10,000 when the case in reality is worth, $200,000, $300,000, okay? That happens all the time. And by virtue of that happening over and over again, it is created this false market for these types of cases where the defendants, the insurance carriers, the defense lawyers, they look at these types of cases and they'll see like the most egregious race discrimination or age discrimination or pregnancy discrimination. They'll see these egregious facts and they'll say, well, Mr. Pollard's crazy. He's over here saying he wants $500,000 or $600,000 for this case. And, we settle cases like this all the time for 20 or 30 grand. And they do. They settle those cases all the time for a fraction of what they're really worth because of the market failure. Okay. So you can avoid a whole lot of that mess by staying out of EEOC mediation. You are under no obligation to participate in it. If it's offered to you and you have a real case, then just say no. In fact, you can just tell the EEOC, I don't feel comfortable participating in this process without a lawyer. You need to give me more time and I'm going to look for a lawyer. And they'll basically just put your case on pause and have your case sit there. Okay. It's unfortunate. Yeah, it's inconvenient. But the reality is you are far better off telling them, no, just pause everything while I look for a lawyer, than you are proceeding forward unrepresented. And the earlier in the process you get a lawyer, the better for you and the better for your case. Jonathan Pollard, happy Monday.